this video, we're going to continue our series and looking at the protections that you enjoy in your private health association and or healing ministry. And we're going to specifically cover your unalienable rights and freedoms via the 14th Amendment. And in light of how they might be challenged with one, avoidance, saying that there's avoidance of public laws, and two, that there's limited association rights. So let's cover again real quick, 14th Amendment, which guarantees that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside, and no state shall make or enforce any law that abridges the privileges of these citizens, or shall the state deprive any person of life, liberty, or property. We look at the 9th Amendment too, and that guarantees those certain unalienable rights to every man, woman, and child. And these not only include our freedom of life, liberty, and property, speech, assembly, and due process, but any right or freedom which is not specifically guaranteed by the Constitution to the government of the Constitution does not assign a specific right or freedom of the government, then we all have a particular right or freedom. So if it's not assigned in the Constitution, then we do have that right or freedom. And just a side note, again, we need to go back to God's law first. These certain freedoms that are assigned by God's law, these particular rights or freedoms, include the right of self-determination, homeschooling, choice of supplies or products and services, choice of lifestyle, food, drink, or any right or freedom that does not infringe upon the rights and freedoms of others or is a threat. So in your private association, we have all the rights and privileges not specifically banned by the association unless they present that clear and present danger. Again, to understand this, we're going to look at how it might be challenged. So number one is saying that the association has been formed for the avoidance of state, local, federal laws. Guess what? That may be true. It's probably true. It's a true statement. The ability of association to do this is well established. The Supreme Court has stated that a state cannot foreclose the exercise of constitutional rights by mere labels. In other words, the label of just avoiding state regulation is not permissible. So we can't, they can't do it just to say, or because they're saying that we're doing it just to avoid. Furthermore, the members of the private association have the right to contract, remember our previous video, with each other and conduct business activities, provided that those activities are not of a substantial evil. We're not committing a mala and say crime. The second objection that comes up, or the second challenge, is the assertion that the association rights are only limited to free speech and advocacy rather than actions like business activity. We have to analyze this, and we're going to analyze it from a practical and a reasonable perspective, because it really kind of doesn't make sense to just say, well, it's only been formed to protect free speech because our free speech is already protected and the advocacy of free speech is protected outside the private association. So why would we even need a private association if that was the only reason that it was formed? Make sense? Yeah. Here's some quotes from U.S. Supreme Court decisions that clearly teach that private association rights are not limited to free speech advocacy but to private association actions and activities beyond the free speech. And I'm just going to go back over these things that we get to do. Right of self-determination, homeschooling, choice of supplies of products and or services. That means our health care, a choice of lifestyle, food, drink, and any rights or freedoms that does not infringe upon the rights and freedoms of other people. So we get to choose how we want to have our healthcare services and who we want to choose as providers and vice versa. All right, some quotes. U.S. Supreme Court stated that in the political realm, as in the academic thought, that's speech and action beyond speech, are presumptively immune, and that's protected from inquisition, illegal attack by political authority, that's government. The U.S. Supreme Court stated that abstract discussion, free speech, is not the only species of communication which the Constitution protects. Vigorous activity, certainly of lawful ends against governmental intrusion. The vigorous advocacy here is the action or activity of actual litigation or the actual filing and follow-up of lawsuits. And one more, the U.S. Supreme Court further stated that in the constant of NAACP objectives, litigation is not a technique of resolving private differences. It is a means for achieving equality of treatment. And just a note that the court referred to litigation as a technique, not free speech. Again, this document is linked below, connected to the previous video and the one that will be following. Please like, subscribe, and share. And we'll see you in the next video.